Good afternoon, everyone. Welcome to Get Ready for 2021 New York Labor and Employment Law Update. Thanks for everyone joining the call. We have several hundred people that are joining and many familiar faces and names among them. So thank you for joining us. I'm Tara Dowd. I'm a partner in the New York City and Long Island offices of the Labor and Employment Practice Group here at Nixon Peabody. I am also the incoming practice group leader-elect for our national practice. And in that capacity, I am pleased to introduce my esteemed colleagues today who will be speaking on the call. We have Stephanie Cafera and Kimberly Harding in our Rochester office, and also Jeffrey Meyer in our Long Island office. Jeff is going to be speaking on wage hour compliance. Stephanie is going to start off with New York paid family sick leave. Kim's going to speak about COVID-19 considerations, and I'm going to follow up at the end with some post-election forecast discussion on the forecast for federal workplace law after the election. So we'll begin with Stephanie. I turn it over to you for a discussion about New York paid sick leave. Excuse me.
Thank you, Tara. Welcome, everyone. Thanks for joining us this afternoon. And as Tara indicated, it's a little confusing between paid sick leave and New York paid family leave. This is the latest mandate from the state legislature, and on the heels of COVID, the legislature wanted to make sure that all New York employees have access to paid sick leave, but typical New York legislature fashion, they made it much more complicated than it needed to be. So let's go through the basics of what the law requires, and then we'll get into a couple of places where we need some more guidance. So the basics of the law: all employers must provide time off for sick leave beginning January 1 of 2021, and nearly all of that time is going to be paid time. Only the smallest employers are going to be exempt from the paid requirement. And the amount of leave that is required to be provided is based on the number of employees that you have. If you have between 5 and 99 employees, you must provide 40 hours of paid leave, and 100 or more, you must provide 56 hours of paid leave. You can either front load this time or allow it to accrue, and if you accrue it over time, it needs to be accrued at a rate of 1 hour of paid sick leave for every 30 hours worked. Exempt employees in this scheme are presumed to work 40 hours. There is no waiting period, so employees are eligible to take this leave immediately upon hire. And the way that the law took effect, it really took effect September 30th, with the idea that employees who are on payroll at that time are beginning to accrue paid sick leave that will then be available for them to use January 1. So if you're not front loading your time, and instead are allowing employees to accrue time, be sure when we get to January 1 that you're giving them credit for the time that they have accrued, at least 1 hour per 30 hours worked from September 30th through the end of December. Carryover is required under this scheme, but you can restrict the amount of time that actually can be used. It's a very strange provision in the law. So unused paid sick leave by the end of the calendar year must be carried over, but you're not required to allow employees to actually use more than the 40 hours or 56 hours of time that they are entitled to. And so what that means is that if you're front loading the time, the carryover doesn't mean anything. If you're accruing the time, it gives employees the opportunity to have some paid time available to them on January 1. The sick leave can be used for a number of different situations covering the employee's illness or the illness of a covered family member, and the family member is defined very broadly to include the employee's child, spouse, domestic partner, parent, sibling, grandchild, grandparent, and the child or parent of the employee's spouse or domestic partner. So a much broader coverage than under the FMLA, much more similar to the New York paid family leave. The employee and family member sick time also can be used for routine healthcare appointments, preventive appointments, as well as for a variety of reasons that relate to domestic violence and sexual violence, stalking, and the like. Documentation, you can require documentation from the employee But there are some limitations, and those are being fleshed out. But as the statute says right now, you cannot require disclosure of the medical condition or the details of the family situation. So similar to FMLA, where you can require documentation, but not disclosure of the actual underlying medical condition. This leave is job protected, and this is one of the areas where we have a lot of questions still unanswered as to exactly what job protected means. But we are clear that the law says you cannot retaliate against an employee for taking paid sick leave, and also the reasons that it's taken must actually be covered by the law. So you are permitted to discipline employees who lie about the reason why they're taking leave. You must provide some notice to your employees. In fact, under the labor law currently, you must have a written sick leave policy. So this is an opportunity, if you don't have one, to create one. And if you do have one, to update it to make sure that it complies with the requirements of the paid sick leave law. Employees also are entitled to request a summary of the sick leave they have accrued and leave that they have used. So in some way, you've got to keep track of this. If you have separate paid sick time, then that will be easy. It will kind of keep track of itself. If you use your PTO policy, you got to have a way to track the hours that are being used for a purpose covered by the sick leave law. So that indicates there's got to be some way of coding this or tracking this time so that you can keep track of which time is being used for a PSL purpose. PSL also can be used to substitute for unpaid FMLA. And if you want to, you can allow people to use PSL to supplement their paid family leave, which is, of course, paid at a partial rate. That's something that you should include in your policy if you want to allow that. We can expect that these record-keeping requirements are going to be part of any audit or review that the Department of Labor does in your workplace. So it is going to be important to keep these records. You must keep them for 6 years, just like other records under New York state law. And failing to comply with all of these PSL requirements is going to be considered a violation or a failure to pay wages under New York law. And like other wage violations, if you were found to be in violation, you would owe not only the amount of the unpaid wages, but also an equal amount in liquidated damages plus civil penalties. So can you keep your existing PTO policy? Yes, as long as it complies with all the requirements under the paid sick leave law. And we're going to talk in a minute about what that means in practice. Those of you who have collective bargaining agreements, any new or renegotiated collective bargaining agreement after September 30th, when the law took effect, must deal with these issues of paid sick leave. And in a nod to the labor relations or the labor relationship, you are allowed to negotiate something that's different from what the law requires, as long as those benefits are comparable. And there's no definition of what comparable means, but you're allowed to make some trade-offs back and forth to provide a different form of benefit to unionized employees if you choose. There are some frequently asked questions that have been issued by the State Department of Labor, and those indicate that the state is taking the position that if you have a new or renegotiated collective bargaining agreement, that you specifically mention the paid sick leave law and identify what benefits are comparable, because they want you to show that you've actually considered this and talked about it in negotiations. And those of you who are in New York City and Westchester, those laws do still apply. Any other state or municipal law, as long as it is equal to or exceeds what's required under the paid sick leave law. So what should you do now? This is one of these laws that is so simple in concept and has become so difficult in practice. We've been fielding so many questions from clients about how to implement this paid sick leave law. If you do have an existing PTO policy, as I indicated, you can keep it as long as it complies, and you can amend it to make it comply. The difficulty comes in tracking the paid sick leave time. If you don't want to pull out sick time from your PTO policy, you need to implement some kind of code to track this time and to be sure that you're not only complying with the record keeping, but more importantly, that you're protecting the time. Whatever protected status means, protected leave means, we can't have that protection unless we know what time is being used for a PSL reason. So that's something that we need to figure out how to do. Some employers are separating out their sick time from PTO. Others are keeping their PTO policy and implementing a tracking system. There are lots of questions that go with that, including a number of employee relations questions, depending on how much paid time you're providing now and in what form. So if your policy is right now very generous, this may be a simple fix. If your policy provides for fewer hours of paid time, complying with this law may require some trade-offs and some reconfiguring of time, and employees may view some of this as a takeaway or as restrictions that they're not very happy about. So there are employee relations aspects to this as well. Plan for some more absences because now we have fully paid 100% sick time with very few questions asked, which makes it more attractive than PFL. So you're going to have employees who will likely use their paid sick leave first because they can get fully paid that way, and then they still have PFL to fall back on. So we have a number of unanswered questions, as I mentioned, the most important of which is what does it mean that the leave is protected? Does that mean it can't be counted for attendance purposes, that you can't discipline any employee for missing that time? Can you count it for attendance bonuses? We're not sure. We're not sure yet if this is protected the way that FMLA is or if it's something else. And as I mentioned, you can't discipline employees for lying about the reason that they're using the leave. We also have questions about multi-state employers. Who counts as an employee? The law says you must count all employees, but it doesn't say where. So we don't know if that means that you have to count just all employees who are in New York State, or whether that means for multi-state employers that you must count all your employees and then only provide leave to employees who are who qualify under the New York law. And we should talk about that, about who is a New York employee. Certainly any employee who is living and working in New York State is entitled to the leave. But in addition, employees who are out of state but come into New York to work also are counted and covered by this leave. People who are working remotely out of state are not covered, but anyone who is coming into New York at any time and providing services on site in New York State is qualified to accrue this leave. So if you are a cross-border employer or you have employees working remotely who come in on a regular basis to provide services in New York, then we need to keep track of those employees as well. There are questions about conversion of time. Employers or clients have asked, well, if I use this, convert the sick time at the end of the year and we have unpaid time that can be carried over but can't be used, can we convert it to PTO or can we pay it out to our employees so that they don't lose the time? We don't know. It's one of those unanswered questions. We're hoping to get some regulations from the State Department of Labor, but those are not forthcoming yet. So those are unanswered questions. Some have also asked, what about a PTO policy if an employee uses up all their PTO earlier in the year and then becomes sick later in the calendar year? Do we have to provide more sick time? Probably the answer is no. We're at least at this point operating on the assumption that just like any PTO policy, employees need to manage their time and save some time for sick purposes. So if you give them the paid time and they choose to use it to go to the Caribbean in January and don't have enough time at the end of the year, that's really up to them to manage. And finally, people have asked about paying shift differential or other add-ons. The statute uses the term normal rate of pay rather than the term of art regular rate. So we don't really know what the normal rate of pay is. kind of assuming at this point that if the rate that they would have been paid includes the shift differential, that you should probably plan to include that. You do not need to pay overtime or tips or gratuities or other add-ons of that nature. So we are awaiting regulations, and hopefully we'll get those soon, but I'll just remind everybody that when the paid family leave law took effect, we got regulations after the law was actually in effect. So as soon as we do get regulations, we will, of course, update you and let you know what those say. And with that, I will turn it over to Jeff.
Good afternoon, everybody. I have the pleasure of talking to you all about wage and hour compliance in 2021 and on. It's sort of the old constant standby thorn in your side. As everybody in HR and employers know, it's not paid family leave, it's not COVID, but it's the old standby pain that we're accustomed to at this point. So to make everybody aware of where this is going, for those who have employees that are minimum wage employees, especially for Long Island, Westchester, and upstate New York, we are going to see another round of increases come December 31st and applicable for all of 2021. Long Island and Westchester will now be up to $14 an hour and will soon hit the city threshold of $15 an hour, which is now the contemplated maximum under New York state law. That's been the benchmark. Started back in 2016. We're now almost there. The rest of New York State, as I mentioned, $12.50. There will be, we anticipate new guidance coming from the Commissioner of Labor in October, where they'll then address increases going forward based upon the CPI and maybe some other indices, whatever the Commissioner of Labor decides to focus on. So stay tuned for that. And to the extent we also have any hospitality employees or fast food workers, especially, just about everywhere now downstate will be at $15 an hour, in line with New York City. The remainder of upstate, north of Westchester, will be at $14.50 and holding for now, subject to possible revisions from the Commissioner of Labor in October coming up. So if we do have those lower wage earners, let's pay attention to this. It's a pothole we'd rather not step in, make sure we are compliant, and make sure we are on top of this. Probably more importantly, to a number of you on the call, our exempt salary test rates for salaried overtime exempt employees is increasing yet again and will increase for another year through 2022. New York City, both large and small employers are now at the cap of $11.25 a week, annualized at $58.5. That number should hold. Long Island and Westchester, we're getting close to that now. We're moving up to $1,050 a week, and upstate New York is a little bit lower, but still almost pushing $50,000, with increases coming in 2022 for downstate and upstate. The critical part of this is, one, a lot of employers focus on the duties aspect of these exemptions, whether there's hire and fire authority, whether there's independent judgment and discretion, whether there's some professional degree for these exemptions. What sometimes slips is the salary test. It's well in excess of what the federal law, the FLSA, requires, and sometimes there's some confusion there. If you're in New York, you are subject to the New York law and these New York rates that we have up on the screen here. Without this, it doesn't matter what duties the employee is performing. They're not going to be exempt if we're not paying them a salary at or in excess of these thresholds and these benchmarks that you see in front of you. So good news, we're getting some consistency throughout the state. If you have employees both upstate, downstate, we are sort of leveling off. The bad news, as always, is that the New York State Department of Labor and the plaintiffs' bar focus on these exemptions and are looking to challenge them. There are task force, and we'll get into this a little bit later on the compliance side, But there are task force that the New York Department of Labor has put together to go out and try to attack these exemptions and find violations, especially if we're not paying the right amounts. So focus on the amounts is a first step. That's easy. That's numerical. The harder part is then adjusting the duties of the employee that we want to classify as exempt. That can be done with the help of counsel and with the great HR departments that I'm sure we have on the line here. But let's focus on the easy part and then work towards the more difficult parts. Some other news on the wage front. This specifically applies to any and all developers we have on the line, construction companies. There has been a ton of new work in New York City, especially, as well as upstate on the island for that matter, though. Construction, new projects, whether or not prevailing wage applied was pretty clear in the past. If you were, say, affordable housing, and this is where this is really geared towards, there was statutory and case law exemptions from that. That is no longer. If you are in the process of developing an affordable housing project or similar projects, there is a likelihood come January 1 of 2022. So we have about a year to plan for this, which is going to focus on the costs of and expenses that are affiliated with the project. But if the project is in excess of $5,000 or more, and where 30% of the funding, at least 30% of the funding for the project is coming from public funds, that includes loans, tax credits, abatements, pilot programs, any sort of government money that either flows through or is credited to that project that project will now be classified and covered under New York State's prevailing wage laws. So real world, what that does is take our wage structure from, we'll say $15, but maybe even south of that, depending on the jurisdiction you're in. Nothing stops us from paying more than that, $15, $20, $30 an hour, to prevailing wage rates, which are they're in excess of obviously those lower minimum wage rates. There's also benefits. These rates, depending on the job being done, whether you're a plumber, you're a carpenter, whatever it may be, and depending on the county that you're in, could exceed $100 an hour with benefits rolled into that. So this is a significant increase to the cost of certain projects now in New York State that have to be accounted for as we move forward through 2021 and plan for 2022. There are exemptions, certain residential and school projects, certain non-for-profit projects, and 421A projects, which is another form of effectively a tax credit. So there are some carve-outs, yet, look, a $5 million project is not a very large construction project, seeing what's out there right now. So if there is any sort of funding, financing, or credit that is flowing back to that project, we have to be attuned to that and we have to pay specific attention. There are obviously significant damages on the wage front, not to mention liquidated damages and the same penalties that Stephanie mentioned earlier that flow through the labor law. So we have to be aware of this and we have to address this, especially when we're bidding a project. The cost will be substantially in excess of what we're used to. Another factor, another realm where employers have exposure, depending on the proper classification, is with independent contractors. Whether somebody's an employee or a contractor depends on control. That's what it boils down to. There are various tests, very long tests, a number of elements which we need to focus on. The good news is that on the federal level, there are new regulations that are rolling through the Department of Labor right now that, if implemented, will make it a lot easier to classify employers, specifically the gig economy, Uber drivers and whatnot, delivery workers, that will make it easier to classify them as independent contractors. So take that as the good news. The potential bad news is there's a probability that this will not survive the new Biden Department of Labor and will be stuck in the works of the administration and will never see the light of day. Regardless, we're all in New York here, and the New York State Department of Labor, as we've talked about, focuses on this as well. They're a lot more stringent on their enforcement. They're a lot more aggressive in their enforcement. The test is effectively the same, but the enforcement is what we have to be prepared for going forward. And I only envision, and I'm sure Tara will echo this in her piece later on, we can only envision now enforcement ramping up as we get into 2021 and into 2022. That applies to independent contractor designations. That's going to apply to the overtime exemptions we've talked about. It's happening already. There are new task force that the New York State Department of Labor expressly has put together that's focusing on certain industries. Still a lot of cash industries, but a lot of other financial businesses that they're looking at right now and looking at these exemptions. So let's stay tuned. Let's stay on our toes. It's a constant bark from us on the wage and hour front to get compliant and to focus on what we're doing. You'll hear more from me on this as the year goes on, but it's important that we do pay attention to this and really focus on what we're doing going forward, given the increased enforcement that we expect. So with that, I will spare you the nuts and bolts of additional harping on the issues, and we'll shift it over to Kim for our COVID-19 considerations and update.
Thanks, Jeff. I think the number one question I've been getting from, or I should say the top two questions I've been getting from employers lately are both on the screen right now, because it seems like with the surge in COVID taking place, a lot of employers are getting hit often for the first time with respect to having an employee test positive for COVID-19 after, of course, they've been at the workplace. So everyone's saying, what do I do? What do I do? And the answer is we want to do our own contact tracing. We want to be very proactive about speaking with the infected employee about any individuals at the workplace with whom they had what we would call close contact, and that is unmasked exposure within 6 feet of another individual. So we want to identify all of our employees that might have had what we call, like I said, close contact. And then we would want to deny access to the building to any of those individuals. And I think one of the most common confusing parts about this for employers is they'll say, well, and now I have to make the person quarantine, right? And I always have to respond that we don't really have any ability to require employees to quarantine. All that we can do is deny individuals access to our building. And that's what we want to do to make sure that we prevent any further spread. So, so that's really our number one priority, and our big job is to determine who might have been exposed or who is needing to have had close contact. From there, the Department of Health is likely doing its own contact tracing. We may get notified of additional quarantines or additional employees who have been subject to quarantine, and we may need to figure out staffing or what sick leave is available to those employees. But so long as we have done our own due diligence, talked to the employee, figured out who the employee eats lunch with, who does the employee share close and close spaces with, who does the employee carpool to work with. Hopefully, if we've done our job to date, we've minimized any of those potential opportunities. But again, we want to make sure that we identify any individuals who fall into those categories and make sure to keep them away from the workforce. Similarly, when we're doing this type of analysis, we do want to make sure that we are only disclosing information on a need-to-know basis. And the reason for that is twofold. The first is that employee medical information, including their testing status or diagnosis status for COVID-19, is protected medical information under the Americans with Disabilities Act. And so we want to make sure to keep that information confidential to the best of our ability. But secondly, I've seen a lot of employers kind of have an employee test positive who's been at the work site, and the instinct is to immediately notify the entire staff by saying an individual an employee by this company has tested positive for COVID-19. And really, all we're seeing is that just really creates panic amongst the workforce and really drives people to ask the obvious first question, right, which is, well, who tested positive and did I have exposure? So by doing our contact tracing up front and doing our own due diligence, we can, one, erase the need to send that email, but also give employees comfort that they have been notified if there's been an exposure and they can continue working without further disruption. The second question, which is everywhere right now, is can we mandate vaccines? Hopefully we will have a vaccine very shortly. It sounds like it's any day now, but we want to keep a couple of things in mind when we talk about the vaccines. The first is to understand that from a legal perspective, yes, generally speaking, employers can mandate certain vaccinations, provided that we allow for exceptions in the case of accommodation for disability or religious objectors. It gets a little bit difficult often for employers to be the arbiter of who has a firmly held religious belief, so that can create challenges for employers in the typical situation. But we also, again, can, if we desire, can mandate vaccination from a legal perspective. Now, there are a number of caveats to that. And the first and the big one with respect to COVID-19 vaccinations is that this is the first vaccination that has been approved under the FDA's emergency use authorization. And it has not, we don't have any long-term safety data with respect to this vaccine. Given that, the Federal Advisory Panel on Vaccinations and Immunizations is recommending that this vaccine be voluntary and that employers do not require that the vaccine be mandated. Again, we can go against that guidance, but this is the federal guidance where they're saying don't mandate the vaccine. So we want to keep that in mind. Those are kind of the legal considerations. There's more to just the legal piece of the puzzle, particularly when we come to the COVID-19 vaccination, because it's not just legally can I, but here we also have practically speaking can I. We know that there's a limited supply of this vaccine and that it's a two-part vaccine, meaning that access to the vaccine will be very difficult to get. So from a timing perspective, we want to make sure that we're not going to be accidentally imposing an obligation on our employees that they won't actually, practically speaking, be able to meet. We don't want to almost mandate ourselves out of a workforce. So we really, from a timing perspective, want to think that through. Given the logistical concerns that I just described and the employee relations issues, particularly given many people's strongly held beliefs in opposition to the vaccine or there's concerns over safety, our current recommendation would be, to the best of your ability, make it accessible to employees, make it free if you can, have it similar to a flu vaccine type clinic, maybe put it on site if this is something you're interested in. But again, the current wisdom is not to mandate vaccines for any workforce. Okay. The good news is, even though we're saying you don't necessarily have to mandate vaccines, on the flip side, we also have OSHA, who has determined that our existing interventions to prevent the spread of COVID-19 have been deemed effective. So wearing face coverings in the workplace, requiring social distancing, wiping down surfaces on a regular basis, encouraging hand washing throughout the day, promoting telecommuting to the best of our ability. All of these have been helpful to limit the spread of COVID-19. And so the safety plans that we've developed have been effective. All current evidence to the contrary, I think, as we see the cases spike throughout the country. One thing that is really important, however, to keep in mind with respect to all safety plans, in particular, our requirements to use face coverings or to adopt these certain policies in the workplace, is that these policies are only as good as the means we have to enforce them. And we're getting a lot of questions now where we're finding that some employees are not complying with employer mask mandates, or they're making other dangerous decisions with respect to employee health. And the question is, can we terminate these employees, or can we at least discipline them? And the answer, assuming that it's just on the basis of not wearing a mask or assuming that there's no other kind of overarching legal concerns is, of course, we can always discipline an employee for violating our safety protocols. And here, the risk is really great where the employee may be putting others at risk. So we want to be careful, as always, when we're talking about employee terminations, but we should consider violations of our safety plans and our safety protocols to be subject to disciplinary action, just like any other infraction at the workplace. With respect to record keeping and reporting, it's been a little bit of a mess, I would say, for understanding what exactly OSHA's requirements are. And we know that we've had a number of changes, but I thought it was important just to remind everyone that for those who are required to keep OSHA 300 laws, and for every employer, because we're required to report employee deaths and hospitalizations, I wanted just to remind everybody that we do have recording and reporting obligations with respect to COVID-19. So OSHA has determined that all confirmed cases of COVID-19 that are work-related and that result, like our other reporting and record-keeping obligations, that result in death, hospitalization, or in an injury or illness requiring something beyond first aid, must be subject to the, like I said, the record keeping and the reporting requirements. Now the question becomes, well, what the heck is work related? Because given the pervasive community spread that we're seeing across the nation, it obviously becomes very difficult to determine whether an employee has contracted the virus at work or whether they maybe have picked it up from a family member or someone else in the community. So OSHA has identified a number of factors that are relevant when determining whether a case of COVID-19 has been deemed to be work-related. And that includes, most importantly, I think from our perspective, the investigation that's been done into whether there's a case of work-relatedness. Basically, OSHA is saying it's not going to be an excuse for you just to not look into whether it was work-related. And we want to be able to look at all the evidence that was available as a result of that investigation. So certainly something to keep in mind. We have seen OSHA be pretty aggressive about this, where we fail to report employee deaths that may be work-related or fail to otherwise comply with our record-keeping obligations. Finally, the last piece that I'll touch on is just with respect to thinking through for 2021, what our sick leave or quarantine leave looks like. I think Stephanie really laid it out for us that in New York, we obviously have other sick leave news on our mind, and we actually may be almost happy, if you can believe it, that we have that sick leave coming into effect for employees to take advantage of beginning on January 1, given that the Families First Coronavirus Response Act is slated to expire on the last day of this year. We currently haven't seen any movement with respect to Congress passing an extension of this bipartisan legislation, which doesn't mean that it won't happen, but just means that we need to be prepared for if it doesn't. So we want to think through, we want to remember that employees, again, may have access or should have access to New York State paid sick leave. We also still have New York State COVID-19 sick leave available for employees who are subject to orders of quarantine from the local county departments of health, and then any other paid sick leave that might be available to employees. But again, given the contagiousness of this virus, we're going to need to continue to take precautions. And the biggest and best one of those is how do we encourage employees who may be experiencing symptoms or know that they've been exposed, how do we encourage them to stay home? And if the employee is reliant on a paycheck, if they're living paycheck to paycheck, or like many individuals just generally can't afford to miss work, or we have a culture where it's frowned upon to miss work at all, we are certainly going to be in trouble. So we want to make sure that we are, again, encouraging employees to take leave, to work from home, and to stay out of the office or the work site to the maximum extent when we know that they've tested positive, when we know that they've experienced they are experiencing symptoms. or when, again, they have a known exposure. So those are kind of the overarching COVID-19 considerations. Much of it is not new, and it looks like it's going to be here to stay, but we're here to help if you have any questions. So I will turn it back over to Tara to close us out.
Thanks, Kim. Okay, advancing the slide. I want to mention as well that if anybody has any questions that they want to submit for the first three presenters, you may submit them. We will try to save some time here at the end to answer a few questions. I'm sure we can't answer all of the questions that people have asked, but we will try to answer some either during the presentation or follow up afterward. So with everything else covered, I'm going to turn now to federal law and a post-election forecast. As we know, President-elect Joe Biden will be taking office on January 20th, 21. Employers can be sure that there are going to be changes and a big shift in the direction of federal workplace policy over the next 4 years. The question is how much and how soon. So some of the priorities that we know to expect from the Biden administration were items that were discussed during the campaign and positions that Joe Biden had taken during the campaign. Some of the top areas obviously relate to the pandemic conditions that he is inheriting, the importance of paid leave, extending the FFCRA, providing for paid family and medical leave, providing for paid sick leave on a federal level. These are agenda items that came up during the campaign. Certainly, providing additional unemployment benefits is something that he would like to accomplish, enhancements for unemployment benefits, much like we saw earlier in the year in 2020. Workplace safety and OSHA, as Kim mentioned. In addition to that, other areas of focus that we can expect include wage and hour protections and gender pay equity measures. The gig economy and independent contractors will continue to remain front and center and be an area of focus. OFCCP enforcement and rules for federal contractors are something that presidents traditionally have a lot of power to affect, and we can expect that pretty soon from this administration. The National Labor Relations Act is an area, union organizing and rights, employee rights in that area definitely will eventually come in this administration, as I'll talk about in a minute. And then, of course, some other areas include ACA, which is a pending decision at the Supreme Court soon. Biden would very much like to expand and enhance the ACA. Federal privacy legislation and data security, which would relate to employment and employees as well. And then in the area of immigration policy, we could certainly expect a shift there. So the question coming back is how much and how soon? And a lot of that depends on Congress and what happens in Congress. So the Democrats control the House, but right now control in the Senate is undecided with 2 seats in Georgia. Subject to runoff elections. We'll know more after January 4th with respect to those seats. What could happen is that if the Democrats win both seats, we could end up with a 50-50 tie in the Senate, which would give Vice President-elect Harris the ability to cast tie-breaking votes, but that does not change the fact that the filibuster remains a factor. And because of all those conditions and how split the Senate would be, I think it's, and most think that it is unlikely that the Biden administration is going to pursue major legislative initiatives early in this presidency, with maybe a few exceptions. But I don't think we're going to see significant efforts for widespread legislative changes, at least during the first 2 years. What we can expect is that if the Senate is split, that Biden and the administration will focus more on areas within the power of the executive branch to affect. So at the agency level and enforcement level on the executive branch side. The first area of focus as I mentioned, that will come up for Biden is if the FFCRA has not been extended this month by the time it expires before the end of the month. And Kim mentioned that right now it's very unclear as to whether that will happen. If it does not happen during the current administration on a bipartisan level, it is something that Biden may push for shortly after the inauguration. He would like to expand the law to provide 100% wage coverage up to $1,400 a week, and add some additional protections in addition to extending the period, the duration of the legislation. Other areas of potential legislation, again, very much depending on what happens in the Senate over the term of the presidency, but other areas of focus would be paid FMLA leave. Biden has indicated that he supports the Family Act, which is an act that had passed the House previously. It includes a insurance-funded, an insurance component to it, which is jointly funded by the employer and the employee, similar to paid family leave in New York with the medical component. But this would be for paid family and medical leave under the FMLA. Unfortunately for employers, the current version of that bill and others like it do not include preemption. So there had been discussion over a period of time as to whether it could be possible to pass federal legislation providing for paid family and medical leave that could preempt state and local laws, or perhaps even in the area of sick leave. These bills would not preempt. So in addition to the patchwork that New York employers already have to deal with, this would be another layer of complexity that employers would have to deal with on the paid leave front, but it is an insurance component. Paid sick leave under the Healthy Families Act would be a national paid sick leave benefit for personal and family health needs, which is something that Biden has also supported, similar to what we have already in New York. On the FLSA and pay equity front, there are areas of legislation that would be on the Biden wish list. One of them is certainly increasing the federal minimum wage to $15 an hour. President-elect Biden has said that he supports doing that by 2026 over a period of time. He would also support eliminating the tip credit for tipped employees that allow reduced minimum wage. He has voiced support for the Paycheck Fairness Act, which includes gender equity rules, such as eliminating the ability of employers to offer different salaries to people of different genders based on past salary history, or making decisions based on past salary history, which tends to negatively impact the wages of female workers. And that bill also includes wage non-disclosure rules that would prevent employers from prohibiting employees from talking about their wages. In addition, Biden has voiced support for eliminating mandatory arbitration agreement requirements and class action waivers in the employment and wage and hour context. So that's the legislative wish list, which may be more difficult on the agency side. At the Department of Labor, we could see, it's possible that we could see efforts to increase the minimum salary for exempt status for the white collar exemptions above the current rate of $684 a week. Recall that there were efforts previously made under the Obama administration to increase the minimum salary. That did not get through. It's a very complex series of events, but under the Trump administration, there was an increase. Biden may still wish to increase the minimum salary even further. But of course, in New York, minimum salaries are already pretty high, so this is going to have more impact potentially in other areas of the country. The EEO-1 Component 2 reports that also, those date back to the Obama administration as well. it is possible that Biden would pick that up again and pretty quickly go forward with implementing the Component 2 reporting requirement on pay data, again, relating to gender pay equity. And then on the federal contractor front, we can expect to see increases to $15 an hour minimum, a requirement for family-sustaining benefits, and also neutrality requirements with respect to union organizing. The gig economy and independent contractors is something that Jeff touched on, so I'm not going to spend a lot of time on it, but I think the Biden administration would certainly look to strictly enforce existing laws and may also roll back some of the changes that were made on the independent contractors status test recently through rulemaking. So we could see rulemaking taking that in a different direction. If legislation were possible at some point, we could see a federal ABC test, which is a very, based on the California ABC test, which is a very difficult standard for employers to meet. And finally, at the NLRB, National Labor Relations Board, we can expect changes, certainly. President-elect Biden has indicated that he is a union man and he supports union interests very much. The board, though, the winds of change blow slowly at the board. It is an agency that will not turn over immediately in terms of its leadership after the change in administration. It's a 5-member board. Each member has a 5-year term, and the next term set to expire is Bill Emanuel at the end of August of this year. The current general counsel is Peter Robb. Traditionally, the general counsel also does not turn over with the administration. He would complete his 4-year term ending in November 2020, but there is discussion at this point that the Biden administration could decide to terminate him from that position earlier in order to put a Democratic general counsel in place. That would be an unusual and unprecedented move. So we will see what happens with that. But long story short, on the NLRB, I think that we are definitely going to see changes toward more union-friendly and employee-friendly decisions from the board and potentially even rulemaking. But that will not happen during the early months of the Biden administration, and will take longer over the period of 4 years. So we have about 6 minutes left at this point, and I wanted to turn back to some questions here. And if there have been any submitted, we can take a look at those. But let me start with any questions about paid sick leave for Stephanie Cafera. Stephanie, do you have any questions that you'd like to answer?
Yeah, there's a question that's submitted that says, we already give employees 5 sick days. This year, employees have the option to carry up to 5 sick days over into 2021. Do we have to give another 5 sick days in 2021, bringing the total to 10 for the year? If not, what do we do with the extra 5 days in 2021? Your employees are going to get a windfall here because the days that they're allowed to carry over are days that you can't take away from them. The sick leave law means that you're going to start accruing for employees to use on a forward-looking basis. So if your employees end up with any extra time at the end of 2020 that they're carrying over into 2021, that will be on top of the sick days that they're accruing under the new paid sick leave law. What do you do with those days? Well, that's going to be up to you because, as I mentioned, the sick leave law doesn't require you to allow employees to use more than the 40 hours or 56 hours, depending on how large of an employer you are. So you could have that time sitting there that they're not allowed to use. And by the way, you're not required to pay it out upon termination either. So it could be time that ends up being lost to them, or you could allow them to use it. You can always have employees use more time than the law requires. Some employers have taken that extra time and created an extended leave bank for employees to use if they are out on disability or some extended period and they can use that time to supplement. But your employees in this case are going to get a little bit of a windfall. I also had a question about, from an Institute of Higher Education, are the student employees considered to be employees for this purpose? And the answer to that is yes, they are. Even though they're not employees for some other purposes, under the paid sick leave law, everybody is an employee. Your per diem employees, your seasonal employees, your temporary employees, there really are no exceptions. So this is something that you would have to provide to your student employees if they work 30 hours. Every time they work 30 hours, they get an hour of paid sick leave.
Great. Thanks, Stephanie. And I'm going to ask Kim, did you receive any questions about COVID-19 considerations?
Yeah, so I think the prevailing question is with respect to mandating vaccinations for employees in the healthcare industry, which certainly, if you're in a high-risk industry, obviously healthcare, dealing with vulnerable populations, may have different considerations, but I think that we want to consider those high-risk considerations with respect to any industry. Certainly, even in the healthcare industry, we would still have to provide exceptions for employees with religious or medical needs or objections. And in those cases, again, maybe provide an exception like wearing a face covering indefinitely or working in separate areas, things of that nature. But healthcare industry, high-risk employers, again, may have different considerations.
Great. And Jeff, did you get any questions that you'd like to answer?
There were none that were specifically wage and hour focused. But I would just reiterate, like I do all the time, to make sure we're paying our people, especially our exempt employees, the right salary. That's pitfall number one that we're going to see a lot of, especially at the beginning of the year. So make sure we update those numbers.
Okay, great. I think we are just about out of time. So we're going to finish on time. And before we go, I would like to, for everyone who joined and is looking for continuing education credits, the attendance verification code is NPCLE 120820. Again, that's NPCLE 120820. Attendees seeking continuing education credits must complete and return their certificates of attendance and evaluation forms to Vanessa York. Her contact information is listed on the slide in front of you, and you will get copies of the slides. All certificates of completion will be emailed within 45 days after the program. And I want to thank everyone for joining us on behalf of myself and the panel, and we appreciate having this opportunity to talk with you today. Have a good day.